is sponsored by the law offices of Joe Pippen. Learn more at attypip.com. Ask your attorney. Just give him a call. This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now in Tampa. Call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Yes, it's 8:02 in the morning, and we're open for you. And if you have a legal question, all you have to do is to dial the toll-free number, which is 877-943-9673. 877-943-9673. Always appreciate that first call coming in. The format of the show is, hey, I sit here behind a microphone and give out the phone number, and you call with your legal question, and hopefully I can help you, give you some peace of mind, get you a proper direction to go into, and hopefully there are lots of other people listening who also could benefit, at least some of them could benefit from what we're talking about. So the show, Ask an Attorney, all about Florida law, been on for 37 years, longest running continual show that I know of, maybe in the nation, where you've had the same host, same format, and I'm glad to be here. Glad to be here for another interesting morning of legal questions and legal discussions and trying to help people. You have a toll-free number, 877-943-9673. A lot of our questions are on estate planning, wills, trust, probate, guardianship, probate, trust administration, litigation of contesting various aspects of estate planning. Maybe someone has misused what you intended to have them do. Sometimes people just abuse power of attorneys. Sometimes people take wrong actions as personal representative or trustee. We also talk about family law, we talk about real estate law, we talk about personal injury, traffic law, next door neighbor problems. If you have a legal question, we'd love to help you at 877-943-9673. Let's go to our first caller, Andy in Tampa.
Hi, Joe. I just have a question. My mother passed away in January, and she had a will, and I have two sisters, and she willed the house to my one sister that had been taking care of her, and everything's pretty much settled and done. But I was curious about her IRS debt. My mother had some debt with the IRS for past taxes or something, and I don't know that we actually settled that at all. Is there? I mean, the house was sold, and my sister got the proceeds from that. It went through probate and all this, but I'm kind of feeling like there's another shoe to drop.
Yeah, could be. Was your sister the personal representative of the estate?
Yeah, sister one was the executor. Of the estate, and sister two is the one that got the house. And we just sold the house, and she got the proceeds from it.
Well, what the personal representative sister should have done is now a homestead generally is exempt from the claims of creditors. So a homestead generally can pass to the three of you or to one of you as long as it's direct bloodline passed from the free from the claim of creditors. Except there's one creditor that exemption doesn't apply to. Guess who that is? IRS. So basically, if the IRS ever came after that, they would be entitled to the money from the sale of the house.
Okay.
So
that's what I thought too.
Yep.
I don't even know what the amount is, or if they would come after, and if they did, how it would manifest itself. I just wondered if there was any experience with that.
And actually, they could come up after the personal representative. The personal representative is supposed to take care of all debts and creditors. So if the personal representative knew about that might be the person they would file an action against. Not necessarily. Was there other assets in the estate beside the home?
Not really.
No?
No, not really. No.
Now, whether the IRS will make an issue out of a homestead, money, that, remains to be seen. So they can be proactive and maybe talking to a CPA about maybe making a settlement offer on the taxes and see how that goes. If you set back and they come after it, could be worse, but that's just a decision. I would suggest you talk to a CPA about the possible actions of the IRS and what could happen.
Okay.
There's a probability nothing will happen. There's a probability nobody will ever even look into it.
Yeah.
But there's a probability that if the IRS comes looking for their money and then they investigate a little bit and find out there was an estate, and then they're going to find out who the personal representative is because that was a matter of public record, then, there could be a problem.
So it all falls on the personal representative, because we had an attorney that was helping to, manage this thing. And she told them, I've tried, you guys go ahead and get a CPA, talk to the IRS, do whatever, settle this. She just asked the attorney to deal with it, and they never did anything.
Well, she might want to go back and say, I've learned that the IRS is not exempt, is one of those exceptions about homestead, and could have filed a claim, or the IRS should have been notified, perhaps under the creditors, or perhaps it was known by everybody, so they were not an unknown creditor. There are some issues there to be dealt with if the IRS, starts to investigate.
Okay.
So I know that you're concerned about it, but you're not the personal representative, and you're not the beneficiary of the only asset in the estate, which was the home. So it doesn't really have an effect for you, but I can tell you're concerned about your sister. So really, you should
I'm
tell
just
her.
curious.
I tell you what, they replay this show. What station are you listening to?
I don't know.
Well, if you're listening to 570 or 910, they rebroadcast this show on Sundays at 5 o'clock. Get your sister to listen to our conversation.
I'll just talk to her.
Okay. All right. No problem. All right. Very good. All right. Thanks. You're listening to Ask an Attorney all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open for your call. You have a toll-free number, 877-943-9673. That's 877-943-9673. So we had a client come in, the daughter of an estate, this past week or so, and mother had like 17 accounts, financial accounts, something like that, and mother had like 2 of them retitled to her trust. She did a number of years ago. So for some reason, time goes on, she opens new accounts here and there, closes accounts, and when she died, most of her accounts, some were in the trust. I mean, she knew what to do, but most of them were not. And I don't know if 15 is the actual number, but it was a large amount of accounts just titled just in her name. Not jointly held, didn't have a beneficiary, not in the trust. Well, guess what? Those 15 accounts have to go through probate. And even though she had a trust, she failed to get those in the trust. Although she did have a few of the accounts were in a trust. I mean, she knew what to do. She just didn't do it for some reason. So now we have about $500,000 going through probate, when it could so easily have been avoided. Probate fees are expensive and time-consuming. There's court involved. And if you have a trust, you should take the effort to make sure everything is properly titled in the trust. If you have a legal question, you have a toll-free number, 877-943-9673. That's 877-943-9673. 9673. Law office is open. We're open till just before 9 o'clock. We stay open for you. Hey, do you know that your estate plan says a lot about you? For example, if you do nothing, if you do not have a will, do not have a trust, haven't even thought about doing estate planning, and die, well, that says a lot about you, because that says you don't really care. And that, what happens then is the state of Florida, if you're a Florida resident, and I'm only licensed in Florida, by the way, for the show, so if you have a question from another state, I might be able to give you a general thought, but I can't really practice law in that state, so I can't really give you a technical legal answer for it. But if you do nothing and you're a Florida resident, the state of Florida makes a will for you. That will goes through a statutory probate. If you were trying to, I had a client the other day who definitely did not have any documents ever done, had never done a will, never done a trust. She was 80 years old. And so I'm asking her about her family. She didn't have any children, and that might have been a reason she just didn't care, because she didn't have children. I said, well, your parents are deceased, obviously. You don't have children. Do you have brothers and sisters? And she says, well, yeah, I've got 2 brothers and a sister. And I said, well, if you died today, with the way you're set up, your brothers and sisters would share equally under the statute. There's a statutory will. You have one. You don't have one. So if you die today, you have a statutory will that leaves everything under your circumstances to your three siblings. She says, well, I haven't talked to one of my siblings, my brother. I haven't talked to him for 30 or 40 years. I don't want him to get anything. I said, well, she wants to leave to her sisters. So I said, well, if you died right now, your brother would get a third of the estate. Oh, no, I don't want that to happen. I said, well, you got to do something. It was just so hard for her to do something. She didn't really, technically, I don't think she really cared what happened to her estate. But she knew she didn't want to give to her brother. So the deal was she did a trust and left it the way she wanted to do it, and mainly because I think she didn't want anything to go to her brother. Now, suppose a person dies, suppose a younger person dies with young children, and one of those are on special, there's a handicap situation, special needs. Then without a document, and say in this case without a spouse, it goes to that child, and they could lose government benefits. If they have an addiction, they're older and they have an addiction, they could just enable their addiction. Lots of special things that you can do in estate planning. Hey, I'd love to help you. If you have a legal question, you have a toll-free number, which is 877-943-9673. Phone lines are open. They're open at 877-943-9673. And if I can help you in any way, I'd be more than glad to help. Why worry about some legal issue when you have somebody that's willing to help you and talk to you for no charge? And you might not care about helping a lot of other people with your circumstance. Your question could be embarrassing to you. I mean, hey, let me tell you what. I don't have to know your real name. You could just call and say, I'm John Doe. I mean, it doesn't matter to me what your name is. I'm just trying to help as many people as I can. So if you don't be shy about calling, and I don't even care if you use the right city. I mean, you could see John Doe from Pittsburgh, as far as I care. It doesn't matter to me. I'm just talking to you, trying to help. 877-943-9673. That's phone lines are open for your call. You're listening to a live show. It's Saturday morning, June the 12th of 2021. And 877 is the number, 943-9673. Hey, we're also broadcasting the show live today on WeBeam TV. So if you want to watch the show, I know you can listen to it on the radio, but if you want to watch it, you just go on your computer and you type in WeBeamTV.com and you can watch the show. We're also streaming live on Facebook. And if you have a Facebook account, I'd love to join up with you on Facebook. I have a personal page, Joseph Pippen. I have an Ask an Attorney page. And I have the law offices of Joseph Pippen page. If you send me a personal request, I will accept that. Then I send you an invitation to join the Ask an Attorney page. Let's go to Brandon in Palm Harbor. Hey, Brandon. All right, is Brandon there? All right, so we have... All right, so Brandon, they're trying to connect with you or reconnect with you right now. So if you have a question, just hang on there. Okay, Brandon in Palm Harbor.
Hey, good morning, Joe.
Good morning.
Hey, got a question for you. Looking at investing in a real estate property. It's 9 units, 3 triplexes, and the seller is willing to hold paper. He's talking about buying it in a land trust or land contract. So I was curious what your thoughts were on that.
You're talking about a contract for sale?
Yeah, because he's got a mortgage on it, and he was saying that we could structure it as a, I think it was a land contract. I'm sorry,
Land trust?
Yeah, the land trust. Yes, where it wouldn't be recorded, and ultimately the bank most likely would not see it. It wouldn't trigger a due on sale clause, which was what my main concern was. If it had like a due on sale or an acceleration clause, and they called the note due, we were trying to structure it where it's a private sale, and then the payments would just be made to the seller instead of a new bank or a new lender. So structuring it that way.
Well, it sounds like to me you're talking about a contract for sale. So a contract for sale is more like a lease, so you make payments, like rent payments, under that apply toward the purchase, and then at the end of the 10-year lease, you've made all of your payments and the property is yours, basically.
Right. Or we could put some type of a balloon payment on there after 5 or 7 years, and refinance out of it at some point. Do a refi.
Basically, you have an option to buy, and you have a contract for sale, and the payments you make during the interim on the contract for sale reduce the purchase price. So if you have the option to purchase any time during like 7 years for X number of dollars, you could do so, and anything you've paid monthly on the contract for sale reduces the purchase price.
Right.
That could work. The only problem for the purchaser is you don't really own the property until you close on the sale.
Right. But depending, I guess, how you negotiate the terms would be who has the liability if, like a worst case scenario, some type of a electrical line or power issue caused a fire or something like that.
Yeah, you can negotiate that, but in the lease itself, that would usually be the responsibility of the landlord.
Right. Okay. Yeah, that's something that we're looking at doing right now, and I'm just kind of exploring that. So, that's helpful. I appreciate that.
All right, Brendan, I know your last name, too.
You can tell?
All right, yeah, I can tell. But all right, nice talking to you.
Hey, thank you.
All right, thank you. All right.
Bye-bye.
All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, and if you have a legal question, you have a toll-free number, which is 877-943-9673. 877-943-9673. That question makes me think of, you explored my brain and how it works. You would know that when I get a question like that, I'm thinking about other questions and other possibilities. And my question, what came to my mind was during that, well, how would I get that into a trust to avoid probate? So you can do an assignment of interest in a contract, for example, to a trust. So that maybe, and it also depends on the language of the contract, but your beneficiary, say your wife in this case, and I know who that caller was, so that's why I'm using his wife, could have the continuation of continuing those contract payments and have the option to close on the deal during the period of the contract, she would have the right to do that because the whole thing was assigned to their trust or his trust. They might have a joint trust, they might have individual trust as well. So then I'm thinking about, well, listeners would really want to know how they can get, if they own a share of a park, how to get that into a trust. You do an assignment of interest of the share of the park. If you have ownership, a partnership, you could assign your 1/3 ownership of a partnership to a trust to avoid probate. The whole idea is to get things into a trust to avoid probate. And it doesn't really matter what the asset is. There would be a way to assign that to the trust. There are some assets that don't go in a trust. Maybe I'll talk about that in a little bit. Let's go to Sharon in Jacksonville. Hey, Sharon.
Good morning. Hey, good morning.
Morning.
So, I wanted to ask you if it was advisable when setting up an executor for a will, if it's advisable to have two people as the executor, or is it better to have one?
Well, that question is going to vary from person to person. Here's the way I answer that question, though. So if you name two, you have created a check and balance, which in some families is good. You don't put one person in charge all the time. You have two people that have to agree on everything. In Florida, by the way, it's called personal representative. It's not called executor, just so you know, by statute. It's a little different. It's personal representative. So if you name two people to be co-personal representatives, they're a check and balance on everything. So the check and balance is good. On the not-so-good side is that if you have two people, then two people have to sign and agree on everything. And if they don't live, fairly close together, that could really slow down the process.
Mm-hmm.
So basically, if you have one, the personal representative is a job. The job is to handle the probate administration through the court, be responsible, fair, do the right thing, basically. So you need a responsible person that gets along with the others, perhaps, that's going to follow and want to do exactly what your wishes say to do. And if you have an irresponsible person, you usually do give this to a busy person, because a busy person can get more things done than a person who doesn't get things done. So you have, it's a careful consideration of who the personal representative should be.
Right.
And so that's a good discussion I have with clients sometimes, because they're trying to decide if they want to do have a check and balance, slow things down a little bit, or do I want to put the most responsible, trustworthy, financially astute, get it done child in charge, knowing they would handle it properly and quickly and be responsible about it. So I mean, really, it's a good question, and it's just a decision you have to make, basically.
Okay, then I have one other question for you. When you were talking about the woman who had the trust and had opened several accounts and never put them in the trust, what would be the procedure for her, or would have been? Each time she opened an account, would she need to contact the lawyer for the trust to add it, or how would that be done?
No, thank goodness they don't have to contact the attorney every time they open up an account. So I've done our firm has done like 53,000 will or trust packages for people. So, if every one of those had to call me every time they went and opened a new account, I couldn't even barely touch the number of people that would be calling me. No, a trust, I describe it as a bucket. So when I create a trust for a client, I give them a instruction list on how to get things into the trust. So, for example, you came to see me in my Jacksonville office there, and I did a trust for you. I would give you instructions, and you would take the trust and the one-page instruction sheet to your bank, and you would tell the bank, I want to open up an account in the name of my trust. So the bank would say, Sharon, instead of just using your name, Sharon, we're going to use Sharon, trustee, and the date of the trust. So they put the title of the trust, just by mentioning trust and the date of the trust on your title, and then that's in the trust. If you close that account and open another one, you just go to the bank, and you close the account, go to another bank, and say, I want to open up an account in the name of my trust. It's just how you title the account. It's how that works.
Okay, I see. Okay, well, I appreciate your help. Thank you very much.
All right, thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The phone lines are open at 877-943-9673. That's 877-943-9673. If I can help you in any way, I would be more than glad to. And all you have to do is call. So some people, when I do a will for a client and they don't want a trust, if the client does a power of attorney, the power of attorney that we do has a section in it where a person could initial off on giving the person they're giving the power of attorney to create a trust. So an example of how that would work is suppose a person comes in and does a will and the power of attorney / healthcare surrogate living will, and they sign a power of attorney, and I'm discussing with them these special transaction paragraphs that are in there where you have to initial off to grant the power. Most everybody initials off on the powers concerning Medicaid, to be able to get Medicaid if something bad happened and you had to go in a nursing home. One of the paragraphs give the person the power to create a trust. Now, if a client's creating a trust, we don't get them to initial that one. If they don't create a trust, I had a lady the other day that just didn't want to pay the little bit of extra money for a trust. So we get to the power of attorney, and I said, look, you can initial this paragraph right here, and the person we're giving the power of attorney to could create a trust for you. And there's another paragraph there that they could transfer your bank accounts to the trust. So often the person who is named the power of attorney is also the personal representative or trustee of the trust. And if they also have the power, so you have, 15 accounts and you put 14 of them in the trust and you become incompetent or incapacitated, your power of attorney would have the power to change that last account to the trust before you die. And a lot of times people get sick and they just never got around to doing an account. That's a very useful tool to avoid probate. Okay, so let's go to my screen. Says Mr. Walker. How are you, Mr. Walker?
I'm pretty good. Asking a question for a friend of mine, and she is on Social Security still, and she received a check here. Hopefully. She received the letter stating that she was, because of her age, she was going into a retirement scenario off of disability, I guess, monies or something like that. And
I didn't understand. You kind of garbled on that last part. She received a letter from Social Security stating that because of her age, going into 66, years, that she is no longer considered disabled. And so she was thinking, what if she gets herself a part-time job? Because there's a lot of people out here, there's a demand for retirees, they're reliable and what have you. And I thought it was a pretty good idea, but will it affect her money's coming in on the Social Security, Does she have sources of other income that she gets?
No, and that's why she was looking at substituting. I think she pulls down probably around 15 a year.
Hey, Mr. Walker, we have a horrible connection. You're very garbled for some reason and not real clear to understand. So what I'd like to do is to tell you, if you contact me, I can give you the name or how to find a Social Security attorney that could look at the letter and give her some proper advice.
Good to go. And I'm sorry about that. I asked the caller that received it if it,
I don't know.
Yeah,
you just don't have a strong signal, I think, is probably the deal. But I'd be glad to give you some help and find a Social Security disability attorney to look at the letter and advise you accordingly.
Good to go. You have a fabulous program, and you have a great day.
Well, thank you. You too, sir. All right, you're listening to Ask an Attorney, all about Florida law. We're more than halfway through the show. If you have a legal question, I'll be more than glad to help you if I can. Hey, and if I don't know the answer, I'm going to be the very first one to quickly tell you I don't know. I usually can give you a resource or some help and get you put in the right direction. And never sit here and pretend I know everything. I definitely don't. And I still enjoy learning. And a lot of times you can learn from situations and callers, and I can sometimes have never even heard of a question like you're asking me, but I can quickly process it and give you a direction, at least a direction to go to. All right, so you're listening to Ask an Attorney. If you've done the show 37 years, and you can imagine when you have appointments every day and you do radio shows on weekends and you get bombarded with questions all the time, and you don't really know. I love doing radio because one thing is I don't have to prepare for a show because I never know what you're going to ask me. And I never know what path I'm going to go down on a lot of questions and answers and topics even. So that's the beauty of live radio. You just come and be prepared for whatever gets thrown at you. 877, if you'd like to throw something at me, it's 877-943-9673. That's 877. The phone lines are open right now. 877-943-9673. I'd be more than glad to help you. You're listening to multiple stations all over the state of Florida, actually. We're broadcasting today from Tampa, and you're listening on that family of Salem communication stations, or 570, 910, 860, 930. A lot of those have FM components. I think most all of them have an FM component as well. You're also listening to WTAN, which is a local Clearwater, Florida station. You're also listening to 96.3 FM in Sun City Center, WSCQ. They also have an FM component, 101.1 FM. We also have 90.3 FM out of Haines City, Florida, WLVF. Big 50-mile circle around there from Haines City to Davenport to Orlando to Lakeland to Bartow to Clermont. Big circle of stations there. Also 600 AM in Jacksonville carries a show, and every other week I broadcast from Jacksonville. Let's go to Karen calling from Kissimmee.
Hello.
Hey, Karen.
Good morning.
Good morning.
I wanted to ask you about the homeowners association. Generally speaking, can they force you to, or can they force you to accept something that they're planning without asking for permission from the homeowners?
Well, HOAs have strict rules of what you can do and can't do. So could they add a new rule?
Mm-hmm.
Is what you're asking me.
Right. Well, what they want to do is they want to add like a service from a cable provider.
That you have to use?
And they want us to, you're forcing everyone to get it. You have to.
No, I don't think, well, first of all, somebody's going to have to review the HOA agreement, and there's clauses in there on how that can be amended and what they can do and can't do. And if the community has to vote on it, I mean, there are all kind of rules and regulations, so I couldn't really answer the question without reviewing the HOA agreement. But generally, I would think that would be very hard for them to do on their own, and forcing you to use a provider and not someone else. I mean, is there a mixture of, that everybody has to use the same one?
They want everyone to use this. They're forcing all the homeowners to use the same provider, and it's going to be attached to the homeowners association where we pay the fees.
I see. I would have a homeowners association, an attorney look at that for you, and maybe get a couple people joined together to have an attorney represent them. And if you have people that are against it, like you appear to be, and you get 4 or 5 people like you that are against it, hire one attorney to represent you, and that would be the best course of action you could do.
Okay, so what type of attorney would that be?
It would be a real estate attorney that deals with home association matters. If you want to contact me, I'll give you a couple of resources of how to find an attorney like that in your area.
Okay. All right, so I'll just call the office then?
Yes, ma'am.
Okay. All right. Thank you very much.
Thank you.
Okay.
Our office number now, not the radio number. The office number is, I'll give you the 800 number, 1-800-226-3529, extension 200. Let's go to Martin calling from Sarasota.
Joe, I appreciate your show, and we enjoy it. It's been around for a while, and I can't tell you the number of things we learned. Let me give you a scenario here that I think a number of people may have. Let's assume that you have a couple that's in their 60s, husband and wife, happily married, no children, and one of them later in their 70s and 80s gets Alzheimer's. And one concern I think we all have would be if that person with Alzheimer's now becomes a burden and they have to go into a nursing home. How does the trust, or can a trust, protect the assets that doesn't drain the accounts for the surviving spouse that doesn't have Alzheimer's?
Okay, well, great question, and thanks for asking that. So basically, when I do an estate plan for a couple in that circumstance, we also do durable power of attorneys. The durable power of attorney has some special transactions that allow the community spouse to reposition assets in a manner where the nursing home spouse could probably qualify for Medicaid, and the community spouse can keep most of the assets. And as a community spouse, you're entitled to the home. That's an exempt asset. The community spouse can keep the car and like $130,000 of other assets. If the amount of other assets exceed $130,000, then there's some special things that you can do with those assets to also make them exempt. So basically, with the planning, we do the pre-planning, getting ready for Medicaid. It was mainly consists of a power of attorney that's properly prepared where assets can be moved and sheltered and protected, and the nursing home spouse can maximize through their government benefits through use of the power of attorney that we've created. In that circumstance, I think it would be important to have a backup person. They would name each other as a power of attorney, but they would have a backup that could proceed with that type of planning if they both wound up in a nursing home.
Okay, well, let me complicate that a little bit more by this scenario. Let's assume that the primary person who has Alzheimer's is the individual who is the primary breadwinner of the family for years and has probably a much higher Social Security than the spouse who is the housewife and raised the kids.
Mm-hmm.
What happens in that scenario? Is the Social Security considered income, and can that go through the trust and be protected further there?
Well, in Medicaid planning, when a person's monthly income exceeds the amount that would otherwise disqualify them for receiving Medicaid benefits, we create what's called a qualified income trust to capture the extra income. So a person can still qualify for Medicaid and not have to use that extra income. It wouldn't disqualify them. So you have it pass in not to the person but to a qualified income trust. And then there's spousal allowances and things like that based on the income. But the main planning is to protect the principals, so that doesn't have to be used for the person's care, particularly if you're on Medicaid. I have a full-time Medicaid attorney, so if that was a true fact one day, for anyone listening, we have a full-time Medicaid attorney. That's all he does, is to deal with those type of issues and reposition assets and maximize the government benefit of the nursing home and maximizing what the client can keep as their legacy.
Okay, and then one final question, and you probably told me this, and I could probably look it on your website, but what is the cost for setting up a trust?
Are you married?
Yes.
So we have a married couple flat fee for trust. It includes a trust, putting your home into the trust, 2 wills, pour-over wills they're called, 2 power of attorneys / healthcare surrogates, and 2 living wills, and the deed, of course, to your home. It's $895 is the flat fee for everything.
Wow. And in the Sarasota area, do you have an office close by down here?
We have an office in Lakewood Ranch.
Okay. Good. I appreciate all your help.
Yeah.
And thanks for the counsel. It's something I hope we never have to go through, but it's something I saw another family go through. And it was,
now, let me tell you, we have an office in Lakewood Ranch. I don't go to that office. Attorney Dennis Moses does. People from Sarasota that want to see me, they would come to the Sun City Center office, which is not too far from there. So, but it's up to you. A lot of my clients, we can start the process on the phone with a phone interview, and I can send drafts, and then we just arrange where you want the signing meeting to be as well.
Very good. Thank you so much.
All right, thank you. All right, let's go to Joy in Lake Wales.
Good morning, sir.
Morning.
Hi, thank you so much for taking my call. It's probably maybe a bit of dumb questions, but I appreciate sort of getting some feedback on the gentleman before me because he answered a few of the questions that I was wondering. But one thing I was wondering is if you already have, it sounded like if you already have bank accounts or a mortgage or whatever, that you can have them, you don't have to start new accounts, you can have them added on to the trust or something.
Yeah, you just do a name change on the account.
Okay. And also, another question I have is regarding my sister who lives in South Carolina. She's had some issues, and she's sort of been the breadwinner of the household. And now she's getting she had a stroke, and she's getting so that she kind of forgets some stuff and whatever. And I think there's some issues in maybe accounts out there that she doesn't have, she doesn't have a trust as far as I know, and my other sister is the power of attorney. So she should do something where she sets up some trust or something maybe and put all the accounts in something like that so that she can get that.
Yeah, she could have a trust where her sister could be the trustee actively for her now.
Okay.
A trust can be drawn to where, so she would be the grantor, the owner, and creator of the trust, and she can make her and her sister co-trustees, or she can make her sister a backup trustee, or she can make her sister the sole trustee. I mean, you can, it's her document. She can create it based on whatever needs she has, and the attorney takes down the information and gets it done for her.
So I understand that you're just in Florida. So would you have people that you would know that would be maybe able to do something like this? Like I liked the idea that you said you can do a lot of the information over the phone and then kind of get together more for signing documents later instead of having to. She's a bit partially disabled since her stroke, that she's a bit paralyzed, and it's more complicated to get her moving around and whatever.
Yeah, I have. I could give you information on how to find an attorney there in South Carolina if you contact me.
I would just call the office.
Yeah, just call the office.
Is it possible that you could say that number again? I apologize.
Yeah, 1-800. Yeah, 1-800-226-3529.
226-3529.
Yes, ma'am.
All right. Thank you so much for your help today.
Right,
thank you, sir. Appreciate your program.
Good. And it's extension 200 if you're writing that number down to.
Oh, extension 200.
Yeah, that person will take the message and get it to me. Or people use that number to make an appointment, and the person that answers the phone can arrange that, or just a call back.
Fabulous. Thank you.
Thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. Phone lines are open at 877-943-9673. 877-943-9673. If you have a legal question, still have time for your call. Let's go to Barbara in Clearwater.
Hi, good morning. Thank you for taking my call.
My pleasure. What can I do for you?
So, regarding the state, the other gentleman, you did answer a lot of questions I had, but if my husband and I own a vacation home in another state, and we should pass away, and it goes to our 3 children, is there a way to set up the will where you do, if one child wants to sell it and the other 2 are forced to buy them out, and it's quite, like $200,000 or $300,000 to buy that person out. Is there a way you could set the will up that all 3 have to agree to sell it, or,
Well, you could say that, but that's possible that would never happen.
So they would have to.
Let me ask you this: Do you know one that wants the property?
I know one that loves it, one that likes it, and one is, probably would take the money.
All right. Well, let me say this. So the three of them, I mean, you could say 3 equal shares, and they just have to deal with it there. But whoever you put in charge would be making the personal representative, or the first successor trustee would be the one in charge of having to decide what to do. So let's suppose, just I'm going to make this extremely simple, just making up some numbers here. Suppose you had a $900,000 estate, and let's suppose you wanted to do 3 equal shares. One of the three could choose the $300,000 out-of-state property as their share, and then take that, and the other two would divide 600 in whatever form that was in. One can purchase it and give the other two promissory notes for the difference if the math didn't work out as smooth as I just said, which it probably wouldn't. They could negotiate themselves, or the trustee could just say, look, we don't have an agreement. All three of us don't want it, so I'm going to sell it and just split the cash. And the one that really wants it can use their share as at least the down payment or most of the payment, and finance the rest and purchase it from the trustee. Okay. There's always a way. I can always think of a way to make this work somehow or another, but those are some of the options you have there.
Thank you. And do you have an office close by Clearwater?
Yeah, I have an office in Largo.
Oh, perfect. All right. Well, thank you.
All right. Thank you. All right, so we have offices. We have several offices in Pinellas, several in Hillsborough, several in Polk. We have offices in Clermont, Leesburg, the Villages. We have office in Jacksonville. So we have offices. We have offices in Lakewood Ranch, Trinity. If you'd like to contact the office, you have a toll-free number, 1-800 to call the office, 1-800-226. 3529 extension 200. If you'd like to email me with a question, or say you want to set up an appointment, my email address is really simple. It's Joe, J-O-E, at A-T-T-Y, the abbreviation for attorney, A-T-T-Y, P-I-P. Those are P's like in my last name, Pippen, P-I-P. So Joe at A-T-T-Y-P-I-P.com. You can send an email with a question. You can send me an email to call, have the office call you for an appointment, and so forth. So let's go to Tom calling from Seminole.
Yes, hi. Parents' estate close to being settled, and total proceeds are, say, $200,000, and there's 4 siblings. Is this subject to personal income tax, like $50,000 each sibling?
Okay, so a person can leave $11 million plus estate tax free, and the only tax that possibly could come into play on that size estate is income tax. So if a person is to receive part of their estate as a retirement account with built-up income, or an annuity with built-up income that's never been taxed, the income tax issue, not the principal amount, not the sale of the home, not a stock that's been stepped up in cost basis. So all of that goes tax-free. It's only the built-up income that's never been taxed that comes out of the state that would be the issue.
Okay. All right. Very good. Thank you.
All right. Thank you. All right, Herman calling. Herman, I'm going to just give you my cell phone number. You can call me in about 10 minutes in my car on the way home. I just don't have time to do your call justice, and we have a minute and 7 seconds left in the show. So my cell number, Herman, if you want to call me around 9 o'clock, is 727-667-3967. Cell number 727-667-3967. Love to help you if I can. Herman, so call me in about 10 minutes. Thanks for listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen. We're here every Saturday morning at 8 o'clock. We're on multiple stations around Florida. The show is repeated on 570-910 Sunday at 5 o'clock. It's also repeated on 96.3 FM in Sun City Center at 5 o'clock. on Sundays. So if you learn something you want to share with someone else or have someone else listen to it, just tune in to those. Also, most of the stations we listen to have podcasts where you can listen to a repeat of the show. If there's something in the show that you want someone else to know, you can find it that way as well. Thank you so much for listening to Ask an Attorney all about Florida law. Be back next week at the same time. You have a safe weekend. So long.
The preceding is sponsored